UN Court declares climate change an existential threat, landmark ICJ ruling explained. In a historic moment, the United Nations highest court has declared that climate change poses an existential threat to our planet, and that countries must fulfill their climate obligations to avoid violating international law. This groundbreaking advisory opinion, delivered at the Peace Palace in The Hague, sets a new precedent for climate accountability and could potentially open the door for affected nations to seek reparations in future legal cases. The International Court of Justice, ICJ, emphasized the urgent need for states to cooperate in cutting emissions, adhering to global climate agreements, and safeguarding vulnerable populations and ecosystems from harm. ICJ President Yuji Iwasawa stated that greenhouse gas emissions are unequivocally caused by human activities and have far-reaching cross-border effects. He further described the climate crisis as an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. But here's where it gets controversial. The court declared that a clean, healthy, and sustainable environment is a human right. This paves the way for further legal actions, including states returning to the ICJ to hold each other accountable and domestic lawsuits. While the ICJ's ruling is not binding, it asserts that countries have an obligation to take binding measures to comply with climate treaties. Crucially, the ICJ stated that industrialized nations have a legal obligation to lead the fight against climate change due to their greater historical responsibility for emissions. The judges also affirmed that countries that signed the 2015 Paris Agreement must ensure their nationally determined contributions, NDCs, are progressive and reflect their highest possible ambition, in line with the treaty's aim to limit global temperature rise to 1.5 degrees Celsius, 2.7 degrees Fahrenheit. Environmental groups have welcomed the opinion, with Oxfam climate change policy lead Nafkot Darby stating that all countries, particularly rich ones, now have to cut their emissions faster and phase out fossil fuels. Danilo Garrido, legal counsel at Greenpeace International, called the opinion the start of a new era of climate accountability at a global level. The opinion was delivered after years of lobbying by vulnerable island nations fearing they could be submerged under rising sea waters. The United Nations General Assembly asked the ICJ in 2023 for an advisory opinion, a non-binding but important basis for international obligations. The landmark opinion of the 15 judges of the ICJ, who all voted unanimously in favor of the opinion, will carry legal and political weight and is likely to determine the course of future climate action across the world, including whether polluters should be made to pay for their actions. The ICJ addressed two key questions: what are states obliged to do under international law to protect the environment from greenhouse gas emissions now and for future generations? And what are the consequences for states whose emissions cause harm, particularly to vulnerable island states? The case was led by the Pacific island nation of Vanuatu and backed by more than 130 countries. Before the ruling, supporters of climate action gathered outside the court, chanting, "What do we want? Climate justice. When do we want it? Now." But this is the part most people miss: the Paris Agreement, which saw more than 190 countries commit efforts to limit global warming to 1.5 degrees Celsius, 2.7 degrees Fahrenheit, has failed to curb global greenhouse gas emissions. Last year, the UN warned in a report that current climate policies will result in global warming of more than 3°C, 5.4 F, above pre-industrial levels by 2100. So, what does this mean for the future of climate action? Legal experts say the ruling is a victory for small island and low-lying states that had asked the court to clarify states' responsibilities. However, the question remains, will countries take the necessary steps to address the existential threat of climate change, or will they continue to prioritize short-term economic interests over the long-term health of our planet? UN court orders wealthy nations to combat climate change, a global legal shift. The highest court of the United Nations has made a significant declaration, asserting that affluent nations are obligated to fulfill their international duties to mitigate pollution. Failure to do so could lead to these countries facing compensation claims from those nations severely affected by climate change. This ruling, celebrated by small island nations and environmental advocates, is seen as a crucial legal advancement towards holding major polluters accountable. The International Court of Justice, ICJ, emphasized the necessity for countries to confront the urgent and existential threat posed by climate change. Judge Yuji Iwasawa, who delivered the court's opinion, stated, states must cooperate to achieve concrete emission reduction targets. He further noted that neglecting the stringent obligations imposed by climate treaties constitutes a violation of international law. The court also highlighted that nations bear responsibility for the actions of corporations operating within their jurisdiction. If countries fail to control fossil fuel production and subsidies, they may be required to provide full reparations to injured states in the form of restitution, compensation, and satisfaction, provided that the general conditions of the law of state responsibility are met. Vanuatu's climate minister, Ralph Regenvanu, expressed his surprise at the favorable outcome, stating, "I didn't expect it to be this good." Vishal Prasad, a law student who advocated for Vanuatu to bring this case to the ICJ, remarked, "This advisory opinion is a tool for climate justice. And boy, has the ICJ given us a strong tool to carry on the fight for climate justice." The human right to a clean environment Judge Iwasawa, leading a panel of 15 judges, asserted that national climate strategies must be ambitious and collectively uphold standards to achieve the goals of the 2015 Paris Agreement, which aims to limit global warming to below 1.5 degrees Celsius, 2.7 degrees Fahrenheit. He stated, "The human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights." Despite the ruling being more robust than anticipated, its effectiveness may be constrained by the actions of the United States, the largest historical emitter of greenhouse gases and the second largest current emitter after China. Under President Donald Trump, the U.S. has sought to dismantle numerous climate regulations. As skepticism regarding climate change grows in the U.S. and beyond, Judge Iwasawa articulated the root of the issue and the necessity for a unified response during his 2-hour presentation of the court's opinion. He stated, "Greenhouse gas emissions are unequivocally caused by human activities which are not territorially limited. Historically, wealthy industrialized nations have been the primary contributors to emissions, and Judge Iwasawa insisted that these countries must take the lead in addressing the climate crisis." Political and legal significance While the court's opinion is not legally binding, it carries substantial political and legal implications, and future climate-related cases will likely need to consider it, according to legal experts. Danilo Garrido, legal counsel for Greenpeace, remarked, "This is the start of a new era of climate accountability at a global level." Haj Narullah, a barrister specializing in climate litigation and counsel for the Solomon Islands in this case, noted that the ICJ has opened the door for potential lawsuits against major emitters. He explained, "These reparations involve restitution, such as rebuilding destroyed infrastructure and restoring ecosystems, and also monetary compensation." 2 key questions The opinion issued on Wednesday followed 2 weeks of hearings in December, during which the judges were asked by the UN General Assembly to consider 2 pivotal questions: what obligations do countries have under international law to protect the climate from greenhouse gas emissions, and what are the legal repercussions for nations that harm the climate system? Developing countries and small island states, which are most vulnerable to rising sea levels, sought clarity from the court after the 2015 Paris Agreement's failure to effectively reduce global greenhouse gas emissions. The UN warns that current climate policies could lead to a global temperature increase of over 3 degrees Celsius, 5.4 degrees Fahrenheit, by the year 2100. As activists strive to hold both corporations and governments accountable, climate-related litigation has surged, with nearly 3,000 cases filed across almost 60 countries, according to recent data from London's Grantham Research Institute on Climate Change and the Environment. This ruling marks a pivotal moment in the ongoing battle against climate change. What are your thoughts on the responsibilities of wealthy nations in combating climate change? Do you believe this ruling will lead to meaningful action, or is it merely a symbolic gesture? Share your opinions in the comments.